Chris Borick, the chief assistant in the office, is right to the front here. He was one of the principal investigators and assigned assistant district attorneys on this case, as well as Alan Dryan, senior assistant in the office. To that end, Tom, you're going to have to help out here. To that end, on February 28th, 2014, as a result of accusations made regarding an Orange County legislator, I asked that a special grand jury be impaneled to investigate the Orange County ethics law and any conflicts of interest as they exist in Orange County regarding that legislator. You have now the basic findings that are summarized in my release here and on the board in front of you. The report itself is over 70 pages long and contains in excess of 150 footnotes. You will see in front of you right here, this is the grand jury testimony of the witnesses that testified, over 935 pages of testimony. There was over 117 exhibits that are in front of you here that consisted over 5,000 pages that were examined by the grand jury as well as members in my office. As a result, I am very confident to say here that a very thorough investigation into this matter was conducted. The results are as follows. Legislator A, as it is known in the report, did not commit a crime because the architectural firm had a contract in place with the county long before the firm asked him to consider working for them. The timeline, in essence, is on July 1st, 2013. The firm was notified that the county would contract with it. On September 24th, the county and the firm entered into a contract. The firm that's involved in this first mentioned the possibility of a job with Legislator A in mid-November of 2013. There was a formal job offer by the firm on December 12th, which the legislator accepted on December 16, 2013. The legislator commenced his employment with the firm on or about January 20th, 2014, and resigned on February 5th of that year. In general, conflicts of interest and ethics laws in New York are based upon the general municipal law. The general municipal law, section 801, prohibits municipal officers, which would include a county legislator, from having an interest in any contract with that municipality. Willful violation of those sections can be a crime. Now let me explain what the term willful means in layman's terms. In New York, we have different, what we call culpable mental states. And that is the mental state that's required to commit the crime. The lowest level we have is what we call criminal negligence. It means that there's something that you perceive that could be a problem or a threat, and you don't perceive it as one, but an ordinary person would. That's what we call criminal negligence. Next, we have recklessness. Recklessness is going forward even though you perceive the risk, but you continue to go forward. Then we have what we call knowing, which simply means that you knew the risk, but you proceeded anyway. Finally, there's intentional. And intentional means you intentionally committed a crime. Somewhere near intentional, we have the term willful. And willful is probably the highest culpable mental state that exists in the state of New York. It's pretty much that you intentionally and willfully proceeded even though you knew it was wrong. In this case, the legislator in question notified at least 4 other legislators, the attorney for the legislature, the Board of Ethics, and at least one county department head of his impending employment The grand jury found that the legislator was not hiding his employment and his actions were not willful under the general municipal law. Quite frankly, by notifying these individuals, by telling the attorney for the legislator, and by informing a department head in the county, it would be impossible for this to be a willful violation. The grand jury's investigation included sending 2 letters to every Orange County legislator, other than the subject of the investigation, requesting any information and giving them an opportunity to testify before the grand jury. There was no evidence adduced at the grand jury that the legislator in question did anything to benefit the firm that hired him prior to 2014. Under the Orange County ethics law, the legislator was required to provide written public notice on the official record of the legislature when he intended on accepting the job, and within 10 days notify the Board of Ethics in writing. By his own admission, he testified in the grand jury under a waiver. He did neither.